predecessor's case.
And let me add that. Yeah. Some are more complicated than others.
Okay.
Do you wish to reserve any time for rebuttal?
5 minutes will be fine, Your Honor. And I'm Richard Talley of the Jefferson County Bar. We raised two issues here on this appeal. One, the sufficiency of the evidence in the case. That's an uphill climb. We're well aware of that. But and also the jury instruction was also raised. And I'd like to take them in reverse order. The sufficiency of the evidence here is a real issue in this case. I have never had a case where I had the victims sign sworn affidavits saying that they've been paid back in full, that they didn't feel like Mr. Baskette had done anything wrong. In other words, that no crime had been committed and he had a right to do what he did. Those are actually introduced at trial by the prosecution. In the hearing of this case, one of the alleged victims made a profit of $9,000. Promissory note executed by Marvin Henniger, that particular victim.
So is the state's theory that in the prosecution that the defendant took the money and was not intending to give it back?
Yes, I think that was the theory of their case. He didn't intend to pay it back. But
and was there any evidence that the defendant did anything towards using the money for what he told the individuals that he was going to use the money for?
There was no evidence that he didn't use what he said he would do.
But was there any evidence that the jury heard that he actually like bought farm equipment or whatever with that money?
That evidence is not in the record. That is correct.
In fact, the money was repaid only after indictment, right?
But of course, there was really not a timeline on when it was to be paid. The note had no maturity date. The other transactions were oral. And that's true. He did pay it back afterwards, but he did pay it.
So what about this, though? So on a sufficiency of the evidence question, extremely deferential to the state. Purposefully so, right? Because the appellate court should not unduly interfere with the judgment of the jury. So the United States Supreme Court requires us, among all of the evidence in light most favorable to the state. It requires us to accredit the state's witness. It requires us to disregard all countervailing evidence. Conflicts in the testimony, we presume the jury resolved it in favor of the state. Even if witnesses present affidavits saying that they did not believe there was an intent to deprive the owners of their property, not a jury have believed, given the fact that none of the money was used for the purposes for which the investment was made, and that none of the money was returned until after he was indicted. In fact, there was an intention to deprive the owners of the property. Could it not come to that conclusion?
And certainly they did, Your Honor, come to that conclusion. We're aware of that. But again, looking at the totality of the facts here, it's just hard to see where any crime, particularly an attempt, was committed. And it leads into the second issue we raised regarding the jury instruction. Here, I did not file the notice. I've been in this case for a while. I've filed notice of affirmative defenses many times. And I was frankly shocked when the prosecution raised the objection about the instruction, because it's all we'd ever talked about throughout the entire case. The affidavits of the witnesses, point blank, that they introduced said, no crime was committed here. John Baskette had a right to do what he did. Now, part of the statute, I guess it's Section 3, I guess designed for me, because it gives the court the opportunity to guarantee a defendant what instruction that he should get, even when his lawyer doesn't file a proper notice. And I think that's the real crux of the issue here. The court should have given the instruction to the jury. Claim of right here, the heart of our case, it had been from the inception. And I think that's where the court should grant us some relief, is on that issue.
So even though the General Assembly can create affirmative defense or not,
Correct?
and even provides for a procedural mechanism to assert it, the argument is that we should ignore the statute.
But they also, in the statute drafted on the notice, they give the court for cause the ability to waive the notice requirement here. My question would have been to the prosecution, what would you have done differently if you had gotten the notice? What proof would they have put on differently? There's not anything else that they could have put on. So there was no prejudice at all to the prosecution here. They knew exactly where we were coming from, get-go. And I think that's where we deserve some relief, is in that particular subsection. That's my fault. I take full responsibility for it.
Charlie, there seemed to be, in my review of both of the briefs in the case, there seemed to be some discrepancy about who originally filed the affidavits. I believe, backwards, I believe your brief said the state filed it. I think the state said that you filed it. Who actually filed the affidavits with the court clerk?
I filed them with the district attorney's office and with the court when they were probably me. Probably I did.
How far ahead of trial were those?
Some months. Surprised about it. All right. I think that's where it deserves. Period. That's that filed. But again, those affidavits were filed a good long while before trial with the court and with the district attorney's office. That's all I have.
What other question? Did any of the three victims, they have any kind of relationship with the defendant before they gave him money?
What was that question?
Had they had any relationship, business or otherwise relationship?
Oh, they all knew him. Marvin Henniger knew him from when John Baskette taught school.
But had they done any business transactions before that there was anything in the record?
I don't know that they had done business with him before, but in the technical record, he's done business with a lot of people.
I'm particularly asking about just the three that.
I don't think they knew them. Buddy Mays Funeral Home knew them. In fact, he buried his parents who died while all this was going on. Knew them all well, but business-wise, I don't think that they had. Thank you, Ron.
May it please the court, Brent Cherry for the state. The defendant in this case was convicted of attempted theft of property valued at $60,000 or more, but less than $250,000. At trial, three men testified that the defendant approached each of them separately with a business proposition where they would partner with the defendant to buy unbranded farm equipment with cosmetic defects, which was functionally sound. And then the defendant was going to sell it for a profit, which would then be divided between the defendant and the investor. Larry Mangum wrote a check for $10,000 on February 22nd, 2019. The defendant said he'd have a payout within 30 to 60 days. Mr. Mangum didn't get payment until after charges had been filed. Those charges were filed in August of 2019. Mr. Mangum testified that he received his check from the defendant's lawyer on November 4th, 2022. So that was 2 years and 8 months after his investment had been delivered. Marvin Henniger wrote a check for $29,397 on June 21st, 2019. Interesting amount there. We don't have anything in the record to indicate why it was such a specific amount as opposed to a round figure. At any rate, the defendant said the deal would be done by the end of September. The defendant, Mr. Henniger, received $10,000 in February 2020, another payment later that year, and a final payment in October of 2020. It took charges and 16 months to get his money back. He did testify that he had an additional $9,000 that was paid to him. Herbert Mays gave the defendant $30,000 on June 11th, 2019, and signed an affidavit on June 8th, 2022, saying that he got his money back. So that was almost within a few days of 3 years. Although the defendant made assurances to the investors, telling them, we've bought the equipment, we're trying to sell it, or statements about we're trying to get the money through the system, or whatever, different kinds of assurances, the investigation in the case never found that any money had been used by the defendant to buy any farm equipment, that no transaction ever took place. Now, in this case,
Is there any appropriation?
we don't have any evidence of exactly what happened with the money, Your Honor.
Okay.
Just that it was delivered to the defendant, and after that, during the investigation, they looked at 5 different bank accounts. In one of the bank accounts, and most of these accounts were not most, all of them were either minimal balances or negative balances. Although at one point, one of the accounts, as I recall, showed a bump of $10,000. It was very brief. So the investigation and the evidence does not show what actually happened with this money, but in spite of the best efforts of the state's investigators, it doesn't show that it was ever used for the purposes for which it was given.
I understood what the counsel just said. Only one of them had a note, promissory note, right?
That's right, Your Honor.
Did it have any interest on it?
It did not. It just
Okay, so no interest. The other 2, there were no note, no interest. Due date on, other than an oral statement as to when to give back the money to without a note.
That's right, Your Honor.
So, General, do you concede, though, that proof at least?
Well, Your Honor, I think that at least there's an argument that could be raised by the defendant that he received this money with the consent of the investors for the purpose for which it was given.
Or that he had honest belief he had the right to
obtain the money, but not for not to use the money
for
the way they used it.
Well, so is it the state's position really that the failure to give the jury instruction is completely dependent upon the failure to give adequate notice?
I think that's the only thing that the court relied on. Okay. Yes, Your Honor. There's that simple requirement under the law. But when we look...
No,
that's fine.
But your friend on the other side says, I fully concede I didn't make the timeline. I didn't comply with the statute. The court, though, could have excused my noncompliance because the statute specifically allows instruction to be given, notwithstanding noncompliance, if good cause exists. I understand him to argue that good cause in this case did exist because the state was always on notice of the defense. The affidavit, at least 2 of them anyway, filed sometime in June, was filed shortly before, but that everyone was on notice of that. The state had been given a copy of the affidavits. They've been filed in the trial court record. If the purpose of the notice statute is to prevent the state from being duly surprised at trial, how hasn't that purpose been satisfied here? In other words, why is there not good cause to at least submit?
Well, Your Honor, to be quite candid with the court, and I try to make it a practice to be as transparent and honest and open and upfront as I can be. And as I've thought about this, I mean, the court recognized it or opined at one point that I think there's a reason for this instruction, but you haven't met the statutory requirement. So could it have been given? And I think it could have, sure. But would it have made a difference? And how much does it add to the consent instruction that the court gave? When we're talking about this affirmative defense, basically we're just saying that the defendant believed that he had consent to receive those funds. But when we look at this case, did he have consent to use those funds the way that he was supposed to use them? And I don't think that the evidence supports taking that additional step. The whole crux.
So I thought you were going down a harmless error analysis, and I was expecting you to say, well, the defendant testified at trial, and so all of the information came in. I expected you to say defense counsel argued to the jury in closing arguments that he had a right to have the property and that it was appropriated otherwise, and in fact was paid back. I didn't hear you argue So what is the state's argument?
Well,
with
Your Honor,
respect to
first of all, the defendant didn't offer any evidence at trial, did not testify, did not offer any evidence. So everything that was presented was what was presented by the state. And it's one of those cases where we have essentially what could the jury infer based on the evidence we have? And it's essentially circumstantial evidence. We have no evidence that the defendant used this money for the reason it was given him. No indication that he ever went and bought this farm equipment, that he entered into any negotiation with somebody to buy the farm equipment, and certainly not that he sold it, although the witnesses testified that he had told them that he had taken steps, that he had been involved in these purchases, he was trying to get the equipment sold, which the jury could clearly infer was false, because nothing found by the investigators supported such an assumption.
state's position? State's position, one, despite noncompliance with the statute, is discretionary. No abuse of discretion. There is an abuse of discretion on the record, but it's harmless. State's.
Well, first of all, Your Honor, the statute's pretty clear. It shall not give the instruction if a notice isn't given, and it kind of stops there. So was there an abuse of discretion? And I'm referring to...
I thought that the statute said 3911-204C3, the court may, good cause shown, allow late filing. That looks like a discretionary decision to me.
and I maybe have looked at a different statute. I wrote this down in quotes. If there is a failure to comply with this subsection C, the affirmative defense may not be raised. So
what statute are you referring to, John?
that's 3911-204C.
About 204C3. Court may.
Well, if there's good cause shown, I don't know that there is good cause shown in this case because there was no evidence offered to support a finding that he had such an affirmative defense, that he didn't testify, and there was no evidence offered to show what his intentions were, except
You said he did or did not testify?
did not. And so we have to rely on the evidence that was provided by the witnesses and by the investigator.
Affidavits were introduced at trial, though, right? Did the state introduce the affidavits?
Yes, Your Honor.
Then it rely upon that as part of a good cause challenge?
I don't think that those affidavits really meet that requirement, Your Honor. When we talk about the whole consent issue, I mean, the court gave an instruction on consent and instructed the jury about the fact that consent can be by means of deception, and so it is not real, not true, not effective consent, and that's exactly what happened here. This money was obtained by deception. Now, whether that deception was at the beginning or it happened at some other point, prior to 1989, we had a number of different statutes that were then rolled into the theft statute. We don't have conversion or embezzlement or other theft types of offenses. They're all the same one, but they all require a showing that that these funds or this property was obtained without consent. Now, in this case, without consent can be shown in a couple of different ways. First of all, the fact that there was a deception in the consent, the fact that the defendant essentially lied to his donors about what he was doing with this whole business deal, and then the fact that this money disappeared. And when we talk about money and funds, dollars are fungible property. You give me $1, and I tell you I'm going to go buy a candy bar with this, and then I go use it for another purpose, but I pay you back another $1 later. You never know the difference because every dollar is like any other dollar, whether it's wrinkled or stained or a different serial number, doesn't matter. But if we want to get technical, the money that was given to Mr. Baskette in this case was used for something that the donors did not intend it to be used for, and it's gone, never to return. So essentially, we're talking about a repayment or making up something that happened. As a young man, my father was a very trusting fellow. We lived in a farming community, and we would go to church on Sundays without locking the doors. One day we came home from church, and somebody had come in the house and stolen a number of different items out of the house, some stereo equipment. My dad had a safe up in his office, disappeared. And although we had questions and suspicions about who might have taken that stuff, we just didn't know. It wasn't until years later that one of my older brother's wild friends came to my father, and by this time he'd put his life together and had married, had kids, was active in his church and all those things. And he confessed to my father that he had broken into the house and stolen all these items. And he wrote him a check to try to compensate him for what he had done. This, in essence, is a case like that. This money was taken, it was used for something different, don't know what. I mean, we could speculate forever about...
How do you know that, General? So I wrote it down. You said the money was used and it's gone. How do we know that? From this record, I could not see that the money, in fact, was gone. It looked to me like he just held on to it from the record.
Well, where did he put it, Your Honor? I mean, he has 5 bank accounts, and it doesn't show up in any of them. He's got negative accounts. At one point, there's a $10,000 bump in one of these accounts, and then it's gone. So over all that time, the money just isn't there. Now, where it came from for him to make these other payments years later, don't know. But that's not the same thing.
Maybe he has a safety deposit box.
I'm sorry, Your Honor?
Maybe he has a safety deposit.
It could be. Could be,
you
Your
don't
Honor.
know.
But it's a reasonable inference.
But you don't know.
Don't know, Your Honor. But
That's just question. You don't know from the record.
I was just
You're right.
arguing that, I mean, one fact that if it were in the record would support deprive the owners of the property is false pretenses, misappropriated, spend it for uses other than what the parties have agreed. What I'm trying to ascertain here in this record is if that inference actually exists, that we can draw that inference in the state's proof. The money and then misappropriate.
Your Honor, I think the reasonable inference, and it's circumstantial evidence, but there's no indication of where the money went or what happened to it. It didn't show up in the bank accounts, and he went years without repaying it. So I'm sorry.
So we can't draw any inference in the state's favor. You're entitled to inferences, but you're also entitled to reasonable inferences that are based upon a reason.
Yes, Your Honor. And I think the reasonable inferences here are, first of all, that there's no evidence to show what happened to the money. But the other reasonable inference is that all this time passed, even though these investors were coming to the defendant and saying, hey, what's going on? Where's our money? What's happening? It can be a reasonable inference that this was misappropriated by the defendant's statements that, basically the check's in the mail. Yeah, we've got the deal going. Yeah, you're going to have your money in another 90 days. We can make a reasonable inference based on the passage of time when nothing happened until after charges were filed and the attorney for the defendant got involved in this process.
But if in 2 of them you don't have a note, the third note doesn't have a due date, what difference does that make?
I don't think it makes a difference here, Your Honor, because...
I mean, I'm just trying to figure it out.
Sure. I appreciate that, Your Honor. I mean, this is a sad case because this gentleman, Mr. Baskette, appears to have been a friend of these folks, was understood to be honest. These people thought, I can give you my money and I'm going to get it back with some kind of interest. So, yeah, it's hard.
But they didn't agree to interest.
They did not. They understood it was a business deal. But the money disappeared, and no explanation was given as to what actually ever happened with the money. We don't have that on the record. So it remains a reasonable inference by the jury that this money was used for something, don't know what, but it wasn't used for the purpose it was given to Mr. Baskette to use it for. And he didn't repay it until way down the road. When we talk about the intent to take this money, to steal this money, it may be inferred by the evidence that was presented. As far as the intent to deprive the owner of this property, the way the statute reads, it's going to be permanently, or it can be for such substantial, or to create a substantial diminution in the value or the enjoyment of the property. And the position of the state is that the jury could look at this and say, wait a minute, you took this money, a substantial sum of money, and held on to it, minimum of a year and 4 months, up to 3 years. That constitutes a substantial diminution in the value, the enjoyment, the availability of this money for the defendant to use. So,
One more time. Not being clear, but let me ask the state's position with instruction.
I think there is no good cause here, Your Honor.
Is cause in this interpretation of law, fact, decision.
I think it has to be by abuse of discretion.
Go ahead, finish up.
No, that's all I had.
Are you agreeing it was fairly raised, though? Because I heard you at one point say, he didn't testify, so that leads you to think, well, how does he establish that he had an honest belief? Was it fairly raised by the other proof in the record, the affidavits, for instance?
Well, Your Honor, I was thinking about that this morning. I don't really see that it was fairly raised. I mean, the court thought that it had been fairly raised, but when you look at the evidence that's presented, how can it be fairly raised when you're talking about having an honest belief if the defendant doesn't testify? And I don't want to reflect or take shots at the right not to testify, but how else are you going to establish, hey, I had an honest belief, if you don't actually say, I had an honest belief? All that's left are inferences from circumstantial evidence. The circumstantial evidence here suggests that the defendant did not have an honest belief that he was entitled to this, because he took the money, he lied about what he was using it for, and used it for something that we still don't know what it was used for, whether he was paying other debts and hoping that he would be able to somehow have money later on. Again, that's just, it's not on the record. We can only speculate, and we shouldn't speculate. This is a hard question, and the jury had all this evidence, and a lot of this is just a jury question. And the jury came back and found the defendant guilty. The state would encourage the court to affirm the trial court's judgment.
That's one thing, not in my brief, but this right in the heart of COVID, business was shut down across the state in that time for 12 to 15 months, right in the middle of it. And in the record, the investors talked about heart attack Mr. Baskette suffered during this period of time, a divorce in this period of time, a loss of his job that happened in this period of time. There was some delay here. But again, I think the court, on the instruction, I think that's something this court can look at. The court properly give the instruction. The trial court said, point blank, the evidence raised the defense of claim of right.
At what point in time was in the trial was the request for that instruction made by you? Was it before he testified? Was it after all the proof was in?
It was very quick. Proof went very quick. It was.
So he had already elected not to testify at the point in time.
Yes, Your Honor.
That you made the decision to point out to the court the claim of right.
It was after the proof had come in, before the
obviously before instructions.
Right.
Okay.
Right.
So, Mr. Talley, your friend on the other side, in response to a question from Judge Hickson, which I think is a good question, your friend on the other side said if the defendant did not testify at trial, that he could not have relied upon these particular affidavits because the particular affidavits were not sufficient to rise to the trial court had already found good cause. Had already found that affirmative defense.
Can't answer that question. I'm not sure. What's the question now?
Yeah, so, excuse me. Yes, sir. So your friend on the other side, I heard him say that the affirmative defense was not raised by the proof. The defendant didn't testify, for example. Judge Hickson then asked your friend, what about the affidavits? I heard the state say that the affidavits themselves were not of a quality to raise the issue. What's your best response?
Oh, I think that the affidavits clearly raised that issue.
Why? How?
Well, they say point blank that no crime is committed. Flip side of that coin is you had a right to do what you did here. I think they clearly, the victims raised the issue in their testimony too, and in the affidavits. They all testified, and the affidavits came in through them at trial.
All right. So did the trial court make a finding that the affirmative defense had been raised by the evidence?
Yes.
Okay.
The trial court found that the evidence raised the claim of right defense. That is in the record.
Trial court make any finding then with respect to the timing of the jury instruction and whether good cause exists?
Court never did address that section for people like me that failed to give the notice. That paragraph's 4.3.
Trial court understand that it had the discretion to waive the notice requirements?
It says point blank the court can disregard that. Cause, and I think we had cause. I think testimony, sworn testimony from the victims was cause. Relief on that issue.
Trial court aware that it had the statutory discretion to waive the notice requirements?
I think so. I think so.
Okay, thank you.
Thank you, Your Honor, very much.
Thank you. Welcome to the court. Hopefully we'll see you again. All right, Madam Clerk, if you'll call the next case then, please.